Kenya's Huduma Namba, meaning service number in Swahili, is a biometric digital identity program. It is intended to be the single source of truth about a person's identity.
NIMS is intended to get the details and the data on all of us in the country, to be sure that we have information, biometric information on each one of us, so that when we engage in a project, we know who we are addressing, and when we get services, you are able to get services because you have a number. That's why it's called Huduma Namba. It is essentially supposed to give you a number so that you can obtain services.
Kenya established the National Integrated Identity Management System, NIMS, which is a biometric database of its population in 2019 through a miscellaneous act amending the Registration of Persons Act 1949.
CA was one of the key stakeholders in the process of developing the Huduma Namba, and we find this to be a very significant process because it's leading to digital transformation and the deepening of transformation for Kenya as a whole.
You have one card that, for example, has your driving license, and the same card is the one that has your national ID, and it's the same one that may have your birth certificate. So depending on the service that the citizen wants, they only hold one card, and the service center will read from that card whatever information it needs.
Despite the system having a main objective of being the single point of truth, it raised serious concerns.
The issue of privacy. Then the second issue was about public participation. Then the other one was using Huduma Namba to limit the rights of people or individuals who had no national IDs, because that was a requirement that you must have a national identification card or a passport for you to be registered in Huduma Namba.
What the government could have done before rolling out the Huduma Namba was to inform the public on what is Huduma Namba, what it entails, the benefit, the pros and cons of Huduma Namba.
However, the project was rolled out without the citizens fully understanding what the Huduma Namba was. The uproar was a result of lack of sensitization from the government, also the limited time that was allocated to the process. Consequently, fear became a key driver for a majority of the citizens to get registered.
Nilichukua Huduma Namba kwa uoga ambaye tulikuwa tukiambiwa. Mpaka leo sijajua maana ya Huduma Namba. Nimeandikisha nikapewa mpaka kijikaratasi.
Hata mimi sijui ni ya nini, kwa sababu hata nyingine sikumbuki. Unajua kitu ikikaa sana inapotea.
Most of us tukichukua Huduma Namba, honestly, tulichukua ndio ile out of fear. Lakini hatujui Huduma Namba kwa mayouth yatusaidia vipi.
Mimi sikuelewa maana ya Huduma Namba, kusema tu kweli. Ilichukua kwa vile tukatuma mgombea wa Huduma Namba, itafika at a point utakuwa unapata vitu zingine Kenya, utakuwa unaenda kwa shop nini, tukaa hizo.
Uliambiwa lazima uchukue ndio utalipwa nayo kwa kazi. So hiyo ilikuwa like enforcement, kwa lazima uchukue, usipochukua utalipwa.
What Huduma Namba entails, majority don't know. Those who applied don't know. And in our community, if there are people who applied, they applied because of fear.
Mpaka wakati huu hatujaambiwa ama hatujaelezwa umuhimu wa hiyo Huduma Namba kwetu sisi, maana wakati tulikuwa tumeichukua tulikuwa tunaambiwa maybe watacentralize system information zako kwa data ziwe mahali pamoja, ambapo ukitaka huduma ya NHIF, NSSF, KRA iko centralized in one place. Unapewa namba ambayo utakuwa inakusaidia kwa mambo mengi. Lakini sasa mpaka tuchukue Huduma Namba mpaka wakati huu hatujaona mabadiliko. Walichukua Huduma Namba na serikali ilienda ikanyamaza. Sasa sisi hatujui Huduma Namba, hizo namba zilikuwa ni za kazi gani.
Huduma Namba sikuchukua, nilikuwa mgonjwa sana na kuanga na ile ugonjwa ya kwangu. Sasa wakati huo sikuwa na hiyo harakati ya kuchukua hiyo huduma namba.
Mimi mwenyewe sikuchukua, na chenye ilinifanya nisichukue, sikuona nini itanisaidia, kwa sababu vitu mingi tumekuwa tukisaini nini, tukiambiwa serikali itatusaidia, mpaka saizi hakuna mahali imetusaidia.
Nilichukua Huduma Namba na nilichukulia huko pande ya Prestige Ngong Road. Nilikuwa nafikiria utakuwa na card, so nikitaka huduma yoyote kwa serikali itakuwa na rahisi.
You question why there was IPRS. All the information about my ID, my birth certificate is with government. They said they wanted to clean up their data. How do you clean data through new registration?
Based on the fact that you needed your ID or other primary source of identification to get Huduma Namba, it was apparent that it would now further marginalize these already marginalized groups. Another marginalized group that we were concerned about is refugees and asylum seekers.
I didn't register not because I feared government having my data. Government already has my data. I simply took advantage of my right. When the court ruled that it's optional, I exercised my right not to register. If the court had ruled it's mandatory, I will have registered. So it was not out of protest. It was simply out of choice. I know the majority that registered are saying, where is this card? We registered, we queued, and so what? What is happening? And I think that's a question to government. For those millions of Kenyans who queued, lined up, and registered for Huduma Namba, why did the project just then suddenly just go quiet?
There are still doubts on how Huduma Namba, NIMS, will work, from the storage of data, enrollment of new population without exclusion to the security of the stored data.
Be that as it may, it has its own disadvantages in terms of when the data is breached, the breach is permanent. I cannot now go back and get back my identity if it is stolen or breached.
What are the safeguards that once you have my information, it will be retained, verified, it will be used in a manner that I understand? That data belongs to me as the individual, not government. So how do I know when it is used? By the time NIMS was enacted, Kenya didn't have a data protection law.
Citizen data in government hands has less value compared to citizen data in private sector hands. And to protect that, the Data Protection Act has provision for surveillance. And it's not the only one. I think there's the Terrorist Act and all that. There are steps to be followed before you activate surveillance.
As with Aadhaar in India before it, a similar biometric database for the Indian population, the case of Huduma Namba ended up in court.
The main concern about people is whether the government would be able to access your information without your consent. Then the second aspect of it was the security of the whole system, because the argument was that the system that Kenya was using was similar one to India, which a person can be able to hack and get information from it. The third aspect of it was about the Nubian community, because you'd find a majority of them, despite living in Kenya for quite a long time, they have no identification cards.
You want to collect data, you do not have a data protection law. You want to collect data through something called Huduma Namba, then later you bring in a Huduma bill. You understand? But this was all litigated in the case, and the court found that the government had not really erred and allowed them to continue. So as a person who believes in the rule of law, the government should continue rolling out Huduma Namba, but it should also abide by the requirements of ensuring that before they continue, a strong data protection framework based on the data protection law and international best practice is put in place, as the court properly cited.
Also, excess data would be taken and put on digital platform. So this would raise information such as DNA, GPS. Those informations are a great risk in this era of social media and internet connectivity.
Despite being rolled out in 2019, a decade after piloting, concerns were raised by various actors such as the Nubian Rights Forum.
We have some Kenyans who are marginalized, who are minorities, who are lacking access to documentation, and that is the reason why I went to court.
Kuna msichana wangu lakini ameenda kibarua, hana kitambulisho na saizi ana miaka 30. Ako na watoto wake 2, wajukuu wangu. Na hao wajukuu wangu wameregister Huduma Namba kutoka kwa hii kadi ya clinic. Hakupata, hawana birth certificate kwa sababu mama yao hawana kitambulisho.
Any child that his or her parents has undergone vetting, something that we don't condone, because vetting should be done to people who are in the border areas.
In Kapsabet and Kisumu, you will find Nubians, original Nubians, change their names. The mother tongue already is Luo. My name is Shafi Ali. Those guys there will add Odongo Shafi Ali, so that they cannot face this discrimination.
Kwa nafikiria hii idea nije nibadilishe jina yake, nimwandike Lanila Wairimu hivi.
Inaonesha haki yangu nimenyimwa na serikali.
The case was heard in September 2019, with the ruling handed down on 30th January 2020.
Finally, we got the judgment. The process could still be implemented by the government because it had already been started, on the condition that the government enacts a regulatory framework to ensure that they cover issues of inclusion and data security.
It was unreasonable for the government to want to collect DNA and GPS locations. So those parts of the suit were struck down. But it allowed the government to keep the data that it had collected and to continue collecting data under Huduma Namba, because by the time the judgment was coming out, the data protection law had been passed.
The ruling turned out to have significant implications for Kenya and beyond, having a direct impact on the already rolled out NIMS, as it also adds to the growing body of cases around the world dealing with the challenges posed by centralized biometric identity system. After the interim judgment was delivered, Kenya also passed the Data Protection Act on November 25th, 2019. Data Protection Act, which is intended to give effect to the right to privacy in Kenya's constitution.
Having one set of centralized data, it presents the opportunity to aggregate data in a way that would lead to very precise or close to precise decision making. But in having all those data sets come together, that kind of data set becomes very important and very vulnerable from a data security standpoint.
Centralized databases tend to attract all sorts of, villains or hackers, both insider and outsider. Quite a number of government databases are centralized because that has been the technology over the last 2 decades. But as we proceed into the current decade, there are new technologies on the scene. Blockchain technologies that promote a distributed and more secure way of protecting our data. So from where I sit, I would want to believe that the centralized nature of the Huduma number is perhaps a growth stage. I would want to see more of a design that is distributed and possibly within a blockchain-based system. And there are governments that are already doing that. Estonia comes to mind. They have a digital ID system that is based on blockchain frameworks. And what that means is that it raises the security levels, both from the insider people who may abuse the system, as well as from the external parties that may want to attack the system.
So the opportunity right there then becomes the governance processes of picking this information. How do you store it? How do you process it? How do you share it? How do you destroy it when the information is no longer necessary? So what this will mean across government and private sector, and indeed other actors that will come in to deal with the data generated from Kenyans, is that we all have to step up.
So we need to see concrete results or evidence that that is happening, a multi-stakeholder approach to managing our cyberspace. Even as the technology changes, the people in office are supposed to issue what is known as supplementary regulation or legislation in terms of regulation. And those supplementary legislation through regulation are what keeps up with the technology. As it changes, you flip the regulation to adapt accordingly.
Start with the existing system, NTSA, e-citizen. Test the current data protection law for its strength, utility, efficiency for the protection of all data, both from the government side and from the citizen side. Once you have tested that and seen the gaps, strengthen the data protection within the law itself and the rules and regulations that come to support and operationalize the Data Protection Act.
However, the question remains, can NIMS lead to exclusion with individuals not being able to access goods and services to which they are entitled to?
When you talk issues of digital ID, a digital ID is very integral. It's tied to identity, it's tied to opportunity, it's tied to access. You wouldn't, if you could help it, you would never want to have that conversation as a catch-up.
The importance of having a single number that can be able to tie into the rest is for efficiency, particularly from the citizen perspective. You have a single card that the police on the street can scan and confirm your driving license is up to standard. You have a single card that if you're involved in an accident on the streets and you're taken to hospital, the hospital can scan and your medical records appear. You have a single card that when you're applying for a job, you give the employer your card, they scan, and your certificates from University of Nairobi or wherever appear. So that is the efficiency behind the Huduma number that they were looking for.
But having said that, looking at Kenya within the sub-Saharan space, we are doing very well. Looking at Kenya in the African setup, we are very, very progressive. We do have the necessary frameworks in place. And with the passage of the Huduma Namba Act, which we hope will happen soon, and the passage of the Data Protection Act, which happened in November, I think we are making very good strides. It also is worth noting that the Data Protection Act was passed within a year of the data protection rule in Europe. That's an international kind of piece of a regulatory framework. So we are very much in keeping with best practice. So as far as regulatory frameworks goes, we've got it. But the real catch is when the rubber meets the road.
You have very nice policies, but so what? For as long as you do not have budgets, you have not hired the Data Protection Commissioner, you've not established the office, you have not increased capacity for judiciary, for police around the space of data protection, then those policies just remain good on paper. So government must move to the next stage of implementation. How do we realize the policy objectives? You must hire the Data Protection Commissioner, fund that fella to set up the office, capacity building for the various agencies, including citizens. Many citizens don't know their rights. Right now, you as a citizen, yes, there's no Data Protection Commissioner in place, but the law is in place. And your right to know what government knows about you is there in the Data Protection Act. You can go to court and ask the court to compel the PS Interior to tell you what information he has about you on NIMS, because it's your right to know. So whereas some implementation agencies are not there, the rights still prevail, and it's through capacity building that citizens can begin to enjoy them, to demand and force a culture of data protection and privacy within the society.
Try give nationality to every Kenyan at birth, because we will just be following our constitution. It says that.
Tuliambiwa tutapata Huduma Namba ID, but hatujaipata mpaka leo. So sijui matarajio yangu sioni kama nitaanza nini.
Ukienda huko kwa serikali muambie waache kuandikisha watu kama hana mpango, wafanye kitu iko na mpango, kwa sababu kama hii na mpango watu watakuja wachoke na waseme hii kitu wataki.